Hello, and thanks for joining the Talking Animals Law and Philosophy series. This is our fourth event in Lent term. My name is Raphael Fazel. I am the co-director of the Cambridge Centre for Animal Rights Law and an assistant professor in public law at the University of Cambridge. You're joining us for the 10-year anniversary of the Talking Animals series. So we've been going for 10 years now, which is really exciting. And for the purposes of this anniversary, we're having particularly distinguished speakers. And I'm really keen to introduce our speaker today, who I'm sure most of you will know already. But before I do so, I'd like to say a few words about the format of this event for anyone who's joining us for the first time. So we will begin after my introduction with a presentation by our speaker that will last somewhere between 30 and 45 minutes. After the presentation, I will turn off the recording and we will move to our Q&A. You're all warmly invited to come in with questions or comments. If you'd like to say anything, ask anything, please use the Q&A function, which you find at the bottom of your Zoom app. You can also comment on others' comments and questions, and you can upvote comments as well. So if someone said exactly what you had in mind, then you can just upvote that comment and it will allow me to prioritize the questions as well. So please to come in the Q&A part of this event. As I suggested, we are recording this event, so if you'd like to watch it later, send it to a friend. It will be uploaded to our YouTube channel and website in due course. Okay, with this out of the way, it is now my great pleasure to introduce our distinguished speaker today, and that's Anna Peters, who is director at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, Germany. Professor Peters is also a professor at the universities of Heidelberg, Freie Universität Berlin, Basel, and she's also a William Cook Global Law Professor at the University of Michigan. She was a member of the European Commission for Democracy Through Law, and she served as a legal expert for the Independent International Fact-Finding Mission on the conflict in Georgia. She has published very widely in numerous areas of law, but of particular interest to us, of course, are her leading publications in animal law, which include her book, Animals in International Law, published with Brill, Animals in International Law of Armed Conflict. This is an edited volume that came out with Cambridge University Press. And then she's also the co-editor of Studies in Animal Law, published with Springer. And together with Kristen Stilt and Saskia Stucki, she has edited the forthcoming and highly anticipated Oxford Handbook of Global Animal Law. Today she will be sharing some of her latest research with us in a presentation entitled Global Animal Law and Global Warming. Professor Peters, thank you so much for being with us. The floor is yours.
Yeah, thank you, Raphael, for inviting me and for the kind words for the introduction. That's really exciting that your series is already 10 years old. I was, to my shame, I confess I wasn't aware that it was going on, has been going on for such a long time already. And I'm sorry not to be in the classroom in Cambridge. But yeah, too much things going on here. So yeah, so my talk is about climate law. And I think that the livestock industry is the elephant in the room of climate law. Because as you of course know, livestock farming, meat, dairy, egg, fur, and fiber production is highly detrimental for our climate. But the legal aspects of this connection have barely been addressed. So I hope you can see my slides. Here I give you an overview. I first would like to recap the current available science on the agroclimate issue. And the purpose overall is, of course, to explore how international climate law can be harnessed as a force for good in the direction of a reduction of livestock. Such a reduction would spare billions of animals the suffering of a short and miserable life. And to that purpose, we have to canvass a little bit the architecture of the international climate regime as far as it's relevant for the livestock problem. But my main task will then be to identify several provisions and some cross-cutting principles of the Paris Agreement that together, that's my argument, form a requirement to reduce livestock numbers. And this especially concerns northern states with their livestock industries. And I'll especially focus on the cross-cutting principle of sustainable development. And my argument is that this principle encompasses also social sustainability in the sense of acceptability, which in turn implies a concern for animal welfare. And I conclude that international climate law provides a legal argument in favor of a global reduction of livestock. And that also animal rights are needed as a stopgap to mitigate, to prevent that climate mitigation is mainly performed on the back of animals. So livestock is both a driver and a victim of global warming, because livestock farming is one of the main causes of human-made climate change. It's estimated that at least 14.5% of the human-induced greenhouse gases flow from agriculture, and newer studies even say up to 28% of the greenhouse gases from agriculture. And in agriculture, within these agricultural emissions, animal products make up to 80% of them. And this footprint, this greenhouse gas footprint of livestock, results from mainly three factors. First, the methane freed from the digestive processes of ruminants. So direct emissions, that's on the middle of the slide. Second, the greenhouse gases released from fertilizers and pesticides and transport, so indirect emissions both on the left and right side. And of course, we also have the loss of forest land as a carbon sink, as a carbon sequester, forest that is lost for pasture and feed crop. It's also mentioned on the slide. So for the future, the world population growth of humans and also foreseeable dietary changes in developing states towards more animal-based food are expected to increase the greenhouse gas emissions from food and agriculture up to 80% by 2050. So you see that animal production has an enormous climate relevance, and therefore it also has an enormous potential for climate change mitigation through a system of the food, through a transformation of the food system. Because shifts in global diets to plant-based diets would lead to a huge sequestration of greenhouse gases. It has been even said that without a reduction in animal-based food, limiting global warming to the 1.5 degrees Celsius temperature goal cannot be achieved at all. So that's the facts. Governments, international organizations, and also the food and agricultural sector itself have acknowledged the emission problem and the parallel savings potential of livestock. However, although the various sectors have acknowledged the issue, they continue to treat agriculture with extreme deference. The relevant actors have come up with mainly one solution, namely to make agriculture, including livestock, ever more efficient in order to yield more meat, dairy, or eggs per emission. For example, the FAO, the Food and Agriculture Organization, proposed practical actions towards low carbon livestock. Action number one is boosting the efficiency of livestock production. They say that the livestock sector requires intensified productivity. So it's all about intensifying the animal's yield, the animal seen purely as commodities. And this line of reasoning is, of course, also welcomed by big meat. For example, the German pork factory Tönnies advocates, you see it on the slide, Genuss mit Gewissen, so delectation with conscience, and promises to produce its pork in a sustainable way. But of course, for the animals, a more effective production means ever more suffering. It means less extensive grazing or a complete confinement. It means harmful growth stimulation. It means shorter lives. And for dairy cows, it additionally means shorter pauses between being impregnated again. So this approach to climate law and policy, the strategy to improve the ratio of animal product output and emissions per animal unit, is a disaster for animals. The animals' lives are squeezed out in search for emissions reduction. And therefore, I think that it's urgent to bring to the forefront a more animal-friendly reading of the international climate regime. Such a reading should highlight the imperative to reduce overall animal production levels. And I would say that such an interpretation is doctrinally sound, and I will try to show this in my talk. And therefore, we first of all have to look a little bit at the climate law architecture as far as it's relevant for livestock. So you know that the international climate law is a legal regime created by the United Nations Framework Convention on Climate Change, the UNFCCC, and its progeny, that's the Paris Agreement, and also the Paris Agreement has a follow-up with annual conferences of the parties, the famous COPs. So I will now look at this body of law and I'll concentrate on the Paris Agreement and the post-Paris COPs. So the first point to make is that agriculture and livestock reduction is at all in the legal realm. So the Paris Agreement does not explicitly mention agriculture or livestock, but the Paris Agreement encourages developed country parties, I quote now, to continue taking the lead by undertaking economy-wide absolute emission reduction. So economy-wide means all sectors of the economy. And in 2017, the COP, the Conference of the Party in Bonn, set up the so-called Coronivia Joint Work Group on Agriculture and gave a joint mandate for the two subsidiary bodies of the UNFCCC. These are the two bodies, one science body and one implementation body, to address issues related to agriculture. So there is a mandate. The treaty provision of the Paris Agreement and the subsequent practice demonstrate that livestock is in the purview of the agreement. So, despite the reluctance of the states and the reluctance of the Joint Working Group on Agriculture to address mitigation and livestock reduction, this would not be outside the mandate. But there is one important obstacle for deriving any legal consequences from the Paris regime for the livestock industry, and that's that almost all provisions of the Paris Agreement contain only very aspirational clauses and programmatic phrases with vague language, with sweeping language. I didn't put anything on the slide on that, but it's a known fact that the exact normative statutes and of many clauses of the Paris Agreement are controversial. It's controversial what legal obligations follow, and whether legal obligations follow at all. That said, domestic courts and other law-applying bodies have been slowly carving out legal substance. And often they have used the Paris Agreement as guidelines for interpreting domestic climate law or in conjunction with domestic law. Also, you're surely aware of the International Court of Justice advisory opinion on states' obligations in relation to climate of last year. summer 2025, and this advisory opinion has also identified some legal obligations flowing from the Paris Agreement. So in the following, I will use provisions of the Paris Agreement and also statements of the COP texts as benchmarks without examining in detail their legal nature, which is in many cases controversial. And therefore, when I point out to incompatibilities with state conduct with those provisions of the Paris Agreement, I'm not necessarily saying that these are legal violations of the agreement. However, such incompatible state behavior is a disappointment, and it disappoints the expectations, and it is a failure to honor the, however, soft commitments or expectations, normative expectations set up by the Paris climate regime. So what I want to say here is that it's not only a political problem, but that such shortcomings and incompatibilities are normatively relevant in an international rule-based order. So what I'm talking about is not necessarily hard legal obligations, but expectations and commitments, and there are some that touch on livestock. The Paris Agreement contains several themes which can be made effective as legal arguments in favor of phasing out animal production. The Paris Agreement does not in itself directly set emission reduction goals. That's very important, but I think it's also known meanwhile. The Paris Agreement does not set emission reduction goals, but it rather obliges state parties to, I quote, undertake and communicate ambitious efforts with a view to achieving the purpose of the Paris Agreement. And the purpose of the Paris Agreement is to hold the rise in temperature below 2 degrees Celsius and to pursue efforts to keep it below 1.5 Celsius to pre-industrial levels. And the 1.5 degree goal is the primary goal of the Paris Agreement. That's what the International Court of Justice said in its advisory opinion. These ambitious efforts mentioned in the Paris Agreement must take the form of so-called nationally determined contributions to the global response to climate change. Of course, ambitious efforts is a highly indeterminate term. In the international climate regime, it stands, among other things, for an obligation of conduct, not an obligation of result. The Paris Agreement then further explains the nationally determined contributions. In the jargon, these are called NDCs. These NDCs, the nationally determined contributions, must be in accordance with best available science. They must be prepared, communicated, and maintained, and they must progress over time. However, it's not possible to assess in any schematic or even quantitative approach whether a state party has really complied with the requirement to undertake ambitious efforts. Whether efforts are ambitious enough, of course, depends on the context. Notably, it depends on the financial, technical, social, and geographic situation of a state party. So there is a lot of flexibility here. But despite the flexibility, the term must be interpreted in good faith and also with a view to the purpose of the Paris Agreement. And that leads to an understanding that the requirement of ambitious efforts does set some outer limits for state discretion. That's also what the International Court of Justice said. The discretion of parties in the preparation of their NDCs is limited. The Paris Agreement also foresees something called global stocktake of the nationally determined contributions. And the first global stocktake was in 2022. And in that first global stocktake, only 59 states, and that's so it's less than 1/3 of all states, only 59 states mentioned livestock at all. And the biggest meat producers of the world, China, United States, the European Union, Brazil, and Russia, the biggest meat producers, only 3 of them mentioned livestock as a part of their NDCs. For example, the European Union and Russia didn't mention one single livestock measure. But even those states which did mention livestock only envisage the further optimization of productivity, what I mentioned at the beginning. But the states do not mention any reduction. So only efficiency, but not reduction of the consumption of animal-derived products. They mentioned things also like planting trees on grazing land, better management of manure, so basically cosmetic measures. So the vast majority of states blends out the necessity to reduce the consumption of animal products and the necessity to reduce their livestock as a contribution towards reaching the climate targets. Against the known facts, the current NDC practice with regard to livestock is a manifest failure. It's a manifest failure to undertake and communicate ambitious efforts in terms of the Paris Agreement. There are other provisions in the Paris Agreement that speak against the current trend to scale up and to further industrialize the animal-based production sector. For example, Article 9 deals with climate finance, notably the funding of mitigation and adaptation measures. Climate finance is not defined in the treaty. Climate finance has historically been read to hold a narrow meaning, namely financial transfers between affluent states and poorer states in fulfillment of climate obligations. But of course, climate finance is an open wording, and I think that this open wording allows a broader understanding of finance. This could also include subsidies. This would be in line with the Paris Agreement objective and purpose, and also the International Court of Justice, I again mentioned it on the slide, also mentioned fossil fuel subsidies under the umbrella of finance. And there's also another provision, Article 2(1)(c), that states as an aim making finance flows consistent with a pathway towards low greenhouse gas emissions and climate resilient development. I would say that flows of finance, and notably financial support of economic sectors that have the effect of worsening global warming, can hardly be considered compliant with this provision. And this argument is highly relevant for the livestock climate issue because the livestock sector is one of the most subsidized industries. The conclusion is that the extremely high livestock sector subsidies are not compatible with the finance flow provisions of the Paris Agreement. As a minimum, the maintenance of high subsidies and the obstruction of the growth of low-emission food industries are conduct that is contrary to the nature of the Paris Agreement, or even if we want to speak of violation. But as I explained at the beginning, violation is maybe too strong, but in any case, it's not really compatible. Another theme, greenhouse gas sinks. The Paris Agreement requests the state parties to conserve and enhance as appropriate sinks and reservoirs of greenhouse gases. Food production, and above all, the inefficient supply of nutritions through animals, is the biggest user of land. Agricultural expansion is the biggest destroyer of sinks through deforestation. In order to satisfy the objective of greenhouse gas sinks, agricultural land use needs to be drastically reduced in order to allow for reforestation. A change of food production and a change of food consumption could protect the globally important greenhouse gas repositories. I would say that the provisions of the Paris Agreement on greenhouse gas sinks can plausibly be interpreted as creating expectations in the direction of livestock reduction, falling most of all on the wealthier states of the global north. And that's not only about the sinks, but also about finance and about NDCs. So now let's move to the post-Paris law and post-Paris politics. Further benchmarks for climate action have been gradually fleshed out in the post-Paris process. These declarations and pledges and outcomes and breakthroughs, to cite only some of the labels that are used, these texts contain predominantly political statements. However, the documents, even if only sparingly, also lay down commitments which in some instances are not merely political promises, but they may also have a legal meaning. The texts, as adopted by the conferences of the parties, by the COPs, in the aftermath of Paris, have gradually begun to mention livestock, but only very marginally. At COP26 in Glasgow of 2021, the state leaders adopted the Global Methane Pledge, in which the state leaders vow to reduce global methane emissions at least 30% from 2022 levels by 2030, in 10 years. However, this pledge treats agriculture differentially, and livestock specifically is not mentioned at all in this pledge. No wonder, and not without merit, the chief executive of the US lobby organization, National Cattlemen's Beef Association, commented on the global methane pledge. I quote, "The Beef Association, any way you slice it, that outcome from COP26 was a win for us, for the beef industry." At the COP27 in Sharm el-Sheikh of 2022, the so-called agricultural breakthrough was adopted. And in this context, two agriculture-related initiatives were started. The one is the Food and Agriculture for Sustainable Transformation Initiative, the so-called FAST initiative. And the second is the Agricultural Innovation Mission for Climate, the AIM Climate Initiative. And these instruments are a step in the right direction of compliance with the Paris Agreement, because the Paris Agreement also speaks about cooperative development and transfer of technology. COP28 in Dubai 2023 adopted a decision outcome of the first global stocktake, and this was the first formal comprehensive assessment of the collective progress made towards reaching the Paris goals. And COP28 also adopted the United Arab Emirates Declaration of Sustainable Agriculture, Resilient Food Systems, and Climate. And here, in this declaration, the heads of state and government stress that, I quote, "Any path to fully achieving the long-term goals of the Paris Agreement must include agriculture and the food systems." And the heads of state also affirm that agriculture and food systems must urgently adapt and must transform in order to respond to the imperatives of climate change. However, none of the official COP28 documents mention the livestock sector. COP29, 24, that was in 2024 in Baku, and COP30 last year in Berlin did not say anything meaningful on agriculture at all, and therefore I didn't put them on the slide. Conclusion, the post-Paris process has so far been totally disappointing on livestock. In my next part, I would like to move to cross-cutting principles of the Paris regime that underline and strengthen what I said before, namely that the Paris Agreement in some, let's say, dynamic reading would demand phasing out or at least considerably reducing livestock, especially in large-scale industrial type production sites as we find them in the global north. We have three principles that should inform the practice under the Paris Agreement. This is the common but differentiated responsibility, so-called CBDR principle. Second cross-cutting principle is food security. And the third principle is sustainable development. So I will walk you through these principles and their meaning or their possible meaning for livestock in the next slides. So first, the CBDRNC, common but differentiated responsibilities and respective capabilities in the light of different national circumstances. That's what it's called. It runs through the entire Paris Agreement. And the International Court of Justice said this is a core guiding principle for the implementation of the climate change treaties. This principle, CBDRRC, allows and even mandates that technical capabilities, the country's affluence, and their historical contribution to climate change become legally relevant as factors for differentiation of legal obligations in the climate regime. In other words, not all states have the same obligations, but it depends on their circumstances. And what are the circumstances? Rebecca Williams suggested a novel factor of differentiation to take into account specifically the state's performance in agriculture, because the less developed states are typically also less emission efficient. And she suggests also to take into account the historic and current levels of the consumption and of the emission-intense products in different states. So generally speaking, consumption can and should be recognized as a relevant national circumstance in carbon accounting. And from that perspective, the fact that developed countries fail to address their high levels of consumption ignores a fundamental national circumstance, a circumstance that is driving their contribution to global livestock emissions. The developed states are in different circumstances because these states have the technical and financial means of converting their industries to plant food systems. And in the rich states of the North, the consumer base is also not suffering from a lack of animal proteins or from lack of proteins. If we follow this line of reasoning, countries with a higher consumption of meat should be expected to take more ambitious actions to reduce emissions. One could say that the relative inaction of the developed countries, the rich countries of the North, their inaction on livestock emission reduction is inconsistent with the principle of CBDRRC. Second principle, food security. This is also mentioned in the Paris Agreement. And I find it important to stress that food security does not stand against phasing out livestock in the affluent countries. Quite to the contrary, we could also say that food security encourages a transformation towards plant-based food. The preamble of the Paris Agreement recognizes the fundamental priority of safeguarding food security and ending hunger, and the particular vulnerabilities of food production systems to the adverse impacts of climate change. The Paris Agreement also formulates the objective of increasing the ability to adapt to the adverse impacts of climate change in a manner that does not threaten food production. So food security is kind of seen as a very important break on, as a break. But I think it's worth noting that although 3/4 of the world's arable land is used for livestock, these 3/4 contribute only to 18% of the global calorie supply and to 37% of the global protein supply. These figures show that as a general matter, maintaining or even increasing livestock is counterproductive for feeding the world with proteins. But of course, respecting and fulfilling the objective of food security demands different concrete strategies depending on context. For states in the global south, in which low protein diets are widespread, the supply of proteins must not be endangered. By contrast, populations in the global south suffer rather from illnesses caused by overconsumption of meat. If we understand food security as providing healthy food, then this suggests working against the overconsumption of animal-sourced food in countries of the global north. And food production, first of all, includes agriculture. And the agriculture comprises livestock. However, the language of the Paris Agreement gives agricultural exceptionalism a very strong foothold in the treaty. Agricultural exceptionalism is the political phenomenon that agricultural products and agricultural markets are much less liberalized than other markets. In their NDCs, in the nationally determined contributions and other statements in numerous forums after the Paris Agreement, states have espoused the position that any potential or maybe only future legal mitigation obligation arising in the climate regime would be subject to a legal exemption for agriculture. That's a very typical state position. But why? This agricultural exceptionalism has to do with the multifunctionality of agriculture, because agriculture, in addition to producing food, agriculture is seen to protect the environment, to preserve the landscape, to offer rural employment, and to preserve the traditional lifestyle and the cultural heritage. These are all very important functions, and they are ascribed to agriculture. And they are sometimes only more or less imaginary, but in any case, the agricultural sector therefore has a very high social significance, high political significance, and this translates into a great political power of representatives and lobbyists of the agriculture sector. These actors are able to block any reform, including green transformations. This agricultural exceptionalism has strongly influenced the evolution of climate law. It is a fact of contemporary political processes on all levels of governance, national, European, international, that agricultural lobbyism and the exceptionalism is very strong and can not easily or will probably not be overcome. So therefore, I think the strategy must be to turn the exception into a force for good for animals. So we as animal lawyers would need to explain that one additional and also proper function of agriculture is to safeguard and promote animal welfare as one dimension of the cultural and social functions of agriculture. I now come to the third cross-cutting principle. That's the principle or concept of sustainable development, also part of the Paris regime. And this principle also suggests reducing industrial livestock. Sustainable development is probably best understood not as a freestanding customary norm of international law, but rather as a guideline for the application of more specific rules. In any case, sustainable development is an integral part of the Paris Agreement. It's mentioned more than 10 times in the agreement. Now, my key point is that animal welfare can be understood as one element of sustainable development. Actually, animal welfare has also been, at least implicitly, sometimes explicitly, been integrated into the Sustainable Development Goals, into the SDGs, by some political actors, for example, by the World Organization on Animal Health and even by the United Nations. And you may know that the United Nations Environmental Assembly adopted a resolution on the animal welfare, environment, sustainable development nexus. The argument here is that animal welfare, as a legal principle, forms part of the concept of sustainability. That's my argument. And this can be based on two lines of reasoning. So one argument or one line of reasoning would be that sustainability is not dependent only on technical feasibility, but also on social acceptance. Because no system of production is sustainable if the public finds aspects of this production now or some consequences in the future as morally unacceptable. And therefore, development is unsustainable when it's perceived as morally unacceptable. Of course, the challenge here is to identify the attitudes of publics across the globe, because these would then count for identifying the meaning of an international concept such as morally sustainable development. Therefore, because this is already quite difficult, we could also just pragmatically say that better animal welfare will enable and will facilitate and will reinforce sustainable development due to positive feedback loops between human well-being and non-human animal well-being. And the most obvious co-benefits arise with regard to the SDGs that I put on the slide: responsible consumption and production, the SDG life below water, and the SDG life on land. There are clear co-benefits for humans and animals. So I think it's possible to conceptualize the principle of sustainable development in that way. And we can also say, and I also put that on the slide, that the available legal technique of harmonious interpretation, that is also foreseen in the Vienna Convention on the Law of Treaties, allows or even mandates to interpret treaties, including the Paris Agreement, in the light of relevant rules of international law that are applicable between the parties. These applicable rules must be taken account when they're relevant. And I would say that when it comes to the interpretation of the Paris Agreement, international rules on animal welfare are relevant in that sense. And they are also applicable in the relations between the state parties to the Paris Agreement, which are all states of the world, basically. So I would say that in result, animal welfare can be acknowledged as an implicit principle of climate law entering through the principle of sustainable development. And when it is activated, when animal welfare is activated in this way, it can be held against the harm that international climate law risks inflicting on animals. That's very important now here. It's kind of a key point, namely that the finding that animal welfare is an indispensable aspect of sustainability law, and therefore also an aspect of climate law, is needed. It's important, and it's needed as a legal bar. It's as a bar against the attempts that I mentioned at the beginning, the attempts to mitigate global warming simply by intensified animal cruelty. So I come to my conclusions. I recap. International climate law has so far neglected the livestock sector as an important source of greenhouse gas emissions. And this is a lost opportunity for carbon sequestration. Measures taken by state parties are so far insufficient, both in quantity and in quality, because the Paris regime temperature goals can impossibly be reached without drastic shifts in the food system. The deference given to the livestock sector and the failure to plan for livestock reduction is manifestly not in conformity with the spirit of the Paris Agreement and defeats its object and purpose. To the extent that the Paris Agreement contains legal obligations, the failure to undertake livestock reduction could even be said to be in violation of the Paris Agreement. Moreover, and under the influence of agricultural exceptionalism, those mitigation proposals that are on the table risk harming animals ever more in search of emission reductions. So we need fresh ideas to counterbalance this trend and to avoid sacrificing animal welfare. And therefore, I try to draw attention to one neglected function of agriculture, which is to be a guardian of animal welfare and not only a guardian of animal productivity. And I also suggested that animal welfare or even animal rights can be read into the very complex international climate law regime as a legally relevant consideration. And once animal welfare is acknowledged as an inherent principle of climate law, or at least as a relevant guideline for interpreting the Paris Agreement, then this concept is also can be a legal bar against the proposals to reduce emissions by squeezing out animal lives ever more. And ultimately, this means that especially the industrialized state parties of the Paris Agreement must undertake and communicate ambitious efforts to reduce livestock as part of their nationally determined contributions. So this might seem totally outlandish to turn international climate law or to use or to try to use international climate law in favor of improving the fate of agricultural animals. Because, of course, this branch of law has anyway been disregarded. So, put it differently, climate law, international climate law, is a very, very weak body of law. So, how can we look for help in this weak body of law? Well, I think that we have seen that domestic litigation in which courts have turned to international climate law, have applied and enforced this law through domestic law, is beginning a little bit to bolster international climate law. So it's not a completely, let's say, non-law, so to speak. And therefore, I think that a climate law perspective on livestock can complement the currently dominant food law paradigm that governs agriculture. Because all the technical solutions that are currently produced to make animal production more climate efficient, as propagated by the Food and Agriculture Organization, for example, these proposals spring from the minds of animal production scientists. And these proposals are influenced by a highly globalized food and agro-industry lobbying sector. And therefore, I think we need an animal law and animal rights perspective to rectify this epistemic and political bias. And this would then be, I think, a welcome development, not only for the sake of animals, but also for the sake of human animals and the planet. Thank you.